Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. I'll take just a few moments before we get started and make sure everybody understands the procedure that we're going to be using today. I also have another matter I want to take up. First of all, I realize we've got experienced practitioners here, but each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, the proper way to do that is after you have introduced yourself, but before you begin your oral argument is to request that from the court. You may receive up to 5 minutes of rebuttal time. Obviously, appellee gets no rebuttal time. When you come to the podium, you will see that there's a device on the podium, has 3 lights on it, green, yellow, and red. So long as the light's green, you've got plenty of time. Light turns yellow, you are running out of time, and when the light turns red, you are out of time. We ask that you please respect those time constraints. One very important thing for everybody who's going to argue to realize is this. These arguments are being live streamed. So think about what you're saying. Once you say it, it's out there for everybody to hear it, and we can't pull it back. So just think about it before you say it. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right. I have mixed emotions about what I'm about to tell you for lots of different reasons, but today will be the last day that Judge Golden participates in oral arguments. Judge Golden has announced that he will retire effective January 3 of next year, and we all have had the privilege and honor of serving with him. I've served with him for the past 10 years, I believe it is, on the Court of Appeals, and before that as when he was a chancellor in Shelby County. And I think Judge Golden wants to say a few things. We certainly will miss him, and I don't know that you've seen the last of him, but this is the last official day he's supposed to sit. So Judge Golden.
Well, I'm not sure I'll get all this out, but it's been a distinct honor to serve on this court and the Chancery Court. With my colleagues, Judge Stafford, Judge McGee, Judge Armstrong, and the remainder of the court from the middle and eastern section, I couldn't ask for better colleagues. I'm so grateful of having had this opportunity to serve the people of Tennessee and to participate in interaction with excellent lawyers and with people that I respect at the bar. We have an excellent bar in Tennessee, and it's been an honor to have each of you appear before this court and participate. With me today is my assistant, Natasha Langston, who's been with me for 22 years, ever since I've been on the Chancery Court, and she's continued with me through this entire time. And I want to say thank you to her. I'm so grateful for having had this opportunity to participate in what I believe to be the backbone of our democracy, our judiciary. Thank you, Judge Stafford, Judge McGee, for giving me this opportunity to say a few words, and I look forward to the next phase for as long as it lasts, and to participate whenever I can, and always be available if you need me for anything. And thank you again for this opportunity.
Thank you for your service. We've not seen the last of Judge Golden. I'm very comfortable about all that, but we wanted to be sure that everyone knew that this was a momentous day. 10 years. I remember the day he started. We also have a special guest here today. We don't normally have this, but I wanted to recognize them. We have at least 2 students from the University of Memphis Law School. Is that correct? Raise your hands. There you go. Okay, we appreciate you being here because it is certainly not a short drive from Jackson to Memphis, and hopefully you'll see some good oral advocacy today. So the pressure's on, folks. All right, anything else, Ms. Angie, before we call the first case?
No, Your Honor.
You may call the first case, please.
Codie Lynn Anderson versus Leah Ray Marshall.
Good morning, may it please the court. I'm Lewis Jenkins. I'm here on behalf of Ms. Marshall, the appellant here, and I would like to reserve 5 minutes, please, Your Honor, for rebuttal.
5 minutes?
Yes, sir.
All right, Mr. Jenkins, the pressure's on. They're all looking at you.
Yes, sir. I take your words to heart. I did consider whether your admonition to consider everything I say meant that I should simply waive oral argument, submit my case on the brief, and not have said anything under the "it's better to remain silent" rule, but perhaps
It's always a consideration.
It absolutely is, especially for me, Your Honor. So this is a custody case and a relocation case. The interaction of those 2 issues makes the case a bit interesting and creates at least one of the legal issues that we think this court should consider. My client, Ms. Marshall, was the primary residential parent, the primary caretaker for this child. I'm going to call him CA in this brief, since this is, in this argument, since this is a juvenile court matter, and he's a minor, and there was a dispute over, admittedly, a number of instances where there were problems with the visitation. The juvenile court found that the bulk of those problems had originated in the actions of my client, and you will notice that in the brief those items are not, we didn't appeal the findings about those items. And we did not appeal the determination that the existence of those items created a situation in which the juvenile court needed to consider the best interest of the minor child as far as a further custody determination was concerned. But the decision that the best interest of the child lay in switching the primary parenting from the mother to the father, especially in light of the relocation issues that had not been raised in the petition, creates a situation in which we say this needs to be reversed. I think there were 4 problems with the custody determination. The trial court did make a recitation of the factors that are set forth, but there were 4 problems with the determination. The first one is, I think that even though these incidents happened in which my client her actions had brought up these problems that occurred with the visitation sessions, there was absolutely no explanation by the trial court or finding by the trial court of why what evidence there was that had caused any actual harm or risk of harm or problem with the child. It was undisputed.
You're talking about the best interest, or are you talking about the relocation now?
I'm talking about the best interest, Your Honor. And so I think that had to be the court, in light of the fact that it was undisputed that my client had been the absolute, no question, primary caretaker of this child for his entire life. There was no argument by the other side that my client was an adequate caretaker, that she had provided a good home for the child, that she'd taken care of the child, that she'd gotten the child to the places he needed to be, except with these instances where there was a problem with the visitation. In light of that, in order to put more weight on these instances that occur, I think there had to be some connection of that to the well-being of the child in order for that to play into the best interest. And there was absolutely no evidence of that. The second thing.
I want to clarify something you just said a while ago. You said there, if I understood you correctly, you correct me if I'm wrong, you said there was no evidence of harm to the child. Are you equating harm to the child as part of the best interest analysis?
I am saying that, Your Honor. I'm saying that in determining where the best interest, if there's no, when you're talking about best interest after the child's lived with somebody and that person admittedly has been a very good caretaker, there's no criticism of that person's care of the child. I'm saying that when the reason for the best interest test is these instances where there was a problem with the visitation, in order for that to tip the scale in favor of the best interest of the child being with the other parent, there has to be some connection between those actions and the child's well-being. If I didn't, I may have articulated that.
Are you equating that to harm, though? Because as I recall, probably 30 years ago, perhaps, maybe not that long, 20 years ago, that argument was made and discarded by the Supreme Court of our state, that harm had to be shown.
Well, if I articulated it inadequately, Your Honor, what I'm trying to say is that if in order for these instances of problems with the visitation to be connected to the best interest of the child, there has to be some evidence that it's having an impact on the child's well-being. And I think that, to me, that's, there's no question about that, especially in the context where the trial court found that basically this was even, the factors in the statute were evenly weighted. The trial court's finding was, I believe there were 2 in favor of my client, 2 that weighed in favor of Mr. Anderson, and the rest of them were basically evenly divided. And I'm saying when you've got that kind of balancing act, there has to be something, when you're going to tip the scale, there has to be some connection to the well-being of the child. And that's the way I'm trying to tie it in, Your Honor.
Well, isn't that what the trial court did here?
I don't think it is, Your Honor.
Objectively, you've got, as I understand it, you're not challenging the trial court's factual findings. Would that be accurate?
It's accurate that I'm not challenging the trial court's factual findings that there was a material change of circumstances, and not challenging the trial court's factual findings of these that these instances where there was a problem with visitation had occurred. We are challenging that several of those instances were directly related to what my client perceived as a potential harm to the child, and she was trying to protect the child. And we are challenging the fact that there were 2 other factors which we've articulated in our brief. I think he found that number 5 and number 9 were weighted in favor of my client. There were 2 others which I explained in the brief, I think, which we claimed those factual findings were incorrect because those factors should have been weighted in favor of Ms. Marshall.
Do you want us to reweigh the findings? The court made a specific finding where he said when all of these factors are weighed, it appears to the court that these weigh in favor of Mr. Anderson.
Yes, sir, but I don't think that conclusory determination is enough. There was no explanation of how that occurred. In fact, when he went through, he said these things I think were pretty much evenly divided. And there was no consideration given, number 1, to the fact that my client was trying to, she said, and it wasn't challenged really, that she was trying to protect the child. Number 2, there was no connection between these incidents and any effect on the child. In fact, there was 0 testimony, I think, by anybody that these instances were connected in any way to
Well,
to the child's well-being.
As Chief Justice Kirby has often said, let's parse this a minute. You've got a situation where, admittedly, if I'm thinking about the right case, there was a failure to visit. And the trial court seemed pretty direct in its finding that the visitation issue was because of your client's actions. Am I thinking about this correctly?
Yes, sir.
Okay. Isn't it, using just basically an objective analysis of this, all these missed visitations, opportunities to share time with the child, isn't it reasonable to say that's causing some effect?
It might be reasonable to say that logically, but that's not a factual finding that the trial court. At the trial court, in the abstract, that's a reasonable statement, yes, sir. But I don't think that was a finding in this case.
Well, there was a finding that there was no visitation and it was your client's problem. Or your client was the cause of that. Would that be accurate? Not no visitation, but
yes, sir.
Visitation was extremely limited.
No, I wouldn't say extremely limited, but there were several instances where the trial court found that my client was responsible for the problem.
So in the abstract, logically, what is missing in that analysis?
What's missing?
The trial court saying that's a problem?
Well, the trial court's connection of that to any effect on the child whatsoever. If the trial court thought there was a connection between those actions and it's not, I'm out of time.
Go ahead.
It's not my client's responsibility.
I want to see where you're going with this one.
Well, I think it's the trial court's responsibility to connect that, Your Honor. If that's what the trial court wanted to find, then the trial court could find that, but it didn't.
Okay.
He found that her actions were deliberate and willful, and found her in contempt for 18 separate violations of the court's order.
And that's related to the contempt, which is not part of this appeal, Your Honor.
But still a fact
But
that the court must have considered.
And it is devoid of any connection to the child in that order or any place else in the record.
Well, it doesn't have to do with it has to do with the visitation and your client's failure to allow visitation.
Well, our argument, Your Honor, is that has to do with my client's action, there's no evidence in this record that was having any impact on the child whatsoever. I did not actually mean for that to become the centerpiece of my argument this morning. And so I had several other things I wanted to say, which I guess I'll wait and say on the rebuttal.
As in many conversations with you, Mr. Jenkins, you've run out of time.
That is a frequent occurrence, Your Honor. Thank you.
But
and
you
I'll
still
be
have
back
your
for
rebuttal.
my rebuttal time.
Morning, Your Honors. Matt Willis, the Dyer County Bar, on behalf of the appellee, Codie Anderson. Your Honors, I don't have a lot of prepared comments in this matter simply because I, in fact, as you would assume, rather agree with the rulings of the trial court. I would like to point out from the discussion that the court has had with counsel previously, there's a two-step analysis when determining whether there should be a change of custody. One is there a material change of circumstances when an actual custodial as opposed to modification is made? In this case, no one has contested that there in fact was a material change of circumstances, largely arising from 17 contempts, others that the court said I could have found for contempt, but it wasn't pled because frankly there were enough contempts already being pled and argued. And some of those contempts honestly being not only didn't show up to deliver the child, but intentionally found that the appellant would go to school, pick up the child, and take them home before the end of the day, check them out of school so that visitation could not occur. Once a material change of circumstances has been determined by the court, then the court looks at best interest. And best interest is not harm, as I agree with the court. Best interest is, I'm not even sure that 36.6.106 directly applies in juvenile court as a mandate of law, but it is frequently applied, and it's good posture and good guidance for what amounts to the best interest of the child. And that's a non-exhaustive list. One of those key factors is fostering a relationship with the other parent. And here, the appellant manifested no interest whatsoever in doing that. So did the court put more emphasis on that than the other factors? I don't know. I can't look into Judge Hudson's mind. What I do know is that the judge went through that list exhaustively, found largely, as Mr. Jenkins indicated, almost a tie situation. But a tie doesn't necessarily go to either particular party. It doesn't go to the previous primary residential caregiver. The judge has to make an independent determination, which we at this level review on an abuse of discretion, and say the best interest of this child moving forward from the change of circumstances which I have found is served by this next parenting plan. So when the judge evaluated those factors, following an uncontested finding of a material change of circumstances, he evaluated the factors, and they weighed, in his opinion, as he set forth in his written findings of fact and conclusions of law, that the father should be named the primary residential parent. There's no requirement under Tennessee law, of which I'm aware, that a harm has to be shown, that it's a tiebreaker situation, that ties go to the previous primary residential parent. The judge finds a change of circumstances, and if so, evaluates what the best interest of the child moving forward are. And obviously, Your Honor, I would agree with the discussion that you had with counsel, that denying one of the parents their time with the child, while it doesn't have a psychologist or a psychiatrist testifying this is harming the child, obviously Tennessee law puts great emphasis and great importance upon the child having a relationship with both parents. In this case, one of the parents was effectively denying that relationship with the other parent. This many levels of contempt obviously had to weigh into that, and I agree with counsel that contempt is not what's on trial here today or on appeal here today. However, the appellant's actions clearly and obviously contributed to the situation, both the change of circumstances and the best interest which were found by the court. I believe the court got it right. I believe the record sustains that. I believe there are two other issues. One is the entry of evidence. I know that has not been argued yet. I will say, just generically, unless the court wants to delve into it deeper, the rules of evidence do require more than, if you're going to enter certified business records, require more than providing uncertified copies after hours the day before and certified copies the morning of. Broad discretion.
Was there an offer of proof made of the records?
No, Your Honor, not that I recall.
Can that even be raised now then?
I don't believe so, Your Honor. It was raised in the pleadings, and I just wanted to address that before the court.
I just wanted to make sure I understood factually what occurred.
Yes, Your Honor. As I recall, there was no offer of proof made. And also, as we pointed out, some of these providers could have been called as a witness. So if there was a concern that their records couldn't be subpoenaed in time, a subpoena to show in person was still legally an operative method for their testimony. I will also point out, I know counsel was engaged, as the technical record would show, late in the game, so to speak, and the judge had denied moving the trial because it had been set so many times, and because, for example, there had been orders the previous year. I specifically tell the parties to follow my orders, and then yet there were following contempt petitions. The court obviously intended to get the case heard, but there was also no effort to say, hey, we've issued subpoenas, they're not complied with, we need you to compel the subpoena and extend the trial. Simply providing uncertified records after business hours the day before and certified records day of trial, the judge was correct in his discretion of excluding those records. Obviously, depending on what the records are, and if it's a one-page document with little relevance to anything from a tax document of some sort from the registrar's office, that might be a different story, and the judge might be well within his discretion at that point to say, yeah, this is okay. I'll give you 10 minutes to go read it. But here we're talking about psychological medical records to be used in a custody proceeding.
But if we don't have the records, we don't know.
If we don't have the records, we know that's what they were, but we don't know what they said, Your Honor. Or I guess I do, but I won't, they're not in the record to argue with the court. And Your Honor,
What do you say about the notice of relocation?
that was gonna be my final position. There was already a pending petition filed. The notice was in fact sent. The notice was not objected to, and then the issue itself was litigated. So, first of all, Your Honor, I don't believe there was any prejudice to any party to having that issue litigated on the day of trial, as was anticipated by the parties at the time. Second, I believe that the petitioner, in this case, Mr. Anderson, complied with statutory provisions, gave the notice. The notice contained all of the appropriate information, including the admonition that if no objection is filed, in accordance with part, I believe it's 366108A4, that a statement that absent an agreement, the relocation will be allowed.
Was there any objection ever filed?
No. Certainly not within the time frame. I realize that counsel on the day of trial did state.
That was an oral objection.
It was an oral objection on the day of trial, but it was not made in writing. It was not made timely. And again, I know present counsel came to this case much later than that was sent. That was addressed with prior counsel, but no proper objection was made. The issue was fully litigated. I don't believe, frankly, Your Honor, that that a parent, after they give the notice, if no objection is filed or raised, that they actually have an affirmative action to then move on, absent any action whatsoever by the non-relocating party, to then file another petition. Even if there weren't a pending petition, I don't believe they have that obligation, if there's no objection. But even if the court were to interpret the statute to require the affirmative filing of a petition by the relocating party, regardless of the total non-action of the non-relocating party, in this instance, a petition addressing custody and requesting a modification of that custody to the moving party was already before the court. There would have been no prejudice, and in fact, it would have been undue waste and delay to say, oh, and by the way, you now have to go start yet new litigation after a 2-year delay in order to have this issue heard when it was already ripe to be heard and didn't include any factors that couldn't have been heard at a custody case.
How far in advance of the hearing was that notice provided?
It was several months, Your Honor. I don't remember the exact date standing here, and I apologize.
Several months?
Yes, it was several months. Your Honor, I could look back at the fact section of our brief. I hope that we placed that in there. But it was a significant period of time before.
So if I'm understanding your argument, then this period of time the trial court spent on litigating the relocation issue was superfluous and of no effect.
Your Honor, I believe that that was a perfectly appropriate thing for the trial court to do. I don't believe the trial court was obligated to do that, because I don't believe that the relocation statute was at issue when there was absolutely no action taken by the appellant in regards to that notice. However, I believe that it was a prudent thing for a court to do when the best interest of a child was involved, to litigate all the issues which were or might be before it. And in this case, essentially the same, to use from a different context, but a good one here, the same nucleus of operative facts were going to address the relocation or change of custody, either one, because the same issue at its crux.
Was visitation determined at that point in time?
I'm sorry, Your Honor.
Was visitation determined by the trial court at that point in time as well?
Yes, Your Honor.
Or was that an agreement between the parties?
There was no agreement between the parties. Your Honor, the whole ball of wax was there. Whether we were changing custody or how we were modifying the parenting plan was all before the court, and I think the court was very prudent to address both of those legal issues, because the stability of the child moving forward is advanced by a final and appropriate determination by the court. So leaving strings, I agree the court shouldn't have done, but I don't believe that the court had any necessity to address the relocation issue as a separate trial issue. I'm glad they did, as I think it.
Well, the court
helps to put a pin.
the court actually said that the issues that lead to this court finding a material change of circumstances and it being in the best interest of the child to change custody have nothing to do with a parent relocating.
I understand that, Your Honor. And I know that issue was, the relocation issue was certainly a matter at trial, and it was hotly fought at trial, but I agree with that is the court's determination, and
And it says very little proof was presented in opposition to the relocation other than arguments.
Correct, Your Honor. Essentially, the argument was, it's too far away. So, Your Honor, back to both of your questions, the whole ball of wax was litigated. The relocation, it didn't turn out to matter, but I'm very glad that the judge did it because it puts a pin in that issue so that this child doesn't have yet more litigation which could upset his life on the immediate horizon for him. And Your Honor, unless I can answer any other questions for the court, I believe these are my remarks.
See none. Thank you.
Thank you. So I'll address the relocation issue. I didn't get to talk about it since we got off on the best interest discussion that took up my entire 10 minutes. But the fact of the matter is, Mr. Dunn made an objection to the relocation being presented on the day of trial because it was not included in the pleadings.
Does it have to be?
Yes, sir, it does. If the statute is to be given its effect, I'll read from
The
36.
statute says, if I recall, you send notice that you're relocating, then the other party has a obligation if they object to object.
So I don't think that's what the current version of the statute that was in effect at the time this case was heard, or the 366-108B says, absent agreement by the parents on a new visitation schedule within 30 days of the notice, or upon timely objection in response to the notice. So if there's no agreement or if there's an objection, the relocating parent shall file a petition seeking approval of the relocation. That's, the statute is
Did that happen?
mandatory. No, sir, it did not happen.
Did your client file an objection?
The relocating parent, Your Honor.
Okay.
That's talking, the wording of the statute is the relocating parent. My client's not the one who relocated.
Okay.
So I think that mandatory provision of this.
Mr. Jenkins.
Yes,
It's a
ma'am.
timely objection also, doesn't it? Timely objection.
Absolutely not, Your Honor. It's now disjunctive in
It
36-1.
says, or upon a timely objection.
Or if they don't reach an agreement, or upon a timely objection. They didn't reach an agreement. So the first part of that disjunctive statement was not satisfied, so Mr. Anderson had an obligation to file a petition.
Mr. Jenkins, let me ask you this, and you'll, please excuse my voice today, but did your client object to the notice that was received?
As far as I know, no, it's not. I mean, it's not in the record, so that's all that matters.
Thank you.
But the second part of this statute, Your Honor, of course, says it doesn't tie it to an objection to the notice. It says if they don't reach an agreement or if there's an objection to the notice, the relocating parent has an obligation to file a petition.
And so you're saying they did not reach any agreement either?
Absolutely not. They did not reach an agreement, and the record's clear about them not reaching an agreement. And Mr. Dunn made an objection at the beginning of the hearing about the relocation issue being heard, which, you know, I might add, as Mr. Willis pointed out, there were some other lawyers before us, but, you know, one of the reasons for the pleadings is put people on notice of what's going to be tried. And the relocation issue was absolutely not raised in any pleading.
Did your client object?
Yes, sir.
Objected to the relocation issue being tried?
Objection to the relocation issue being heard. That page number where Mr. Dunn made that objection is cited in our brief, Your Honor. I don't remember it off the top of my head right now.
Did your client object?
Mr. Dunn did. He was representing my client at trial, Your Honor.
Okay.
Yeah, Mr. Dunn, who used to work at my office.
Oh, okay.
Was the lawyer who tried.
Yes, I know who you're talking about.
Yes,
now.
sir. I'm
Okay.
sorry.
So
I
he did
didn't.
object to the relocation issue being
He
tried?
did, yes, sir. At the beginning of the hearing, he made an objection about the relocation issue being heard that day.
Okay.
And I'm sorry I wasn't clear about that. He's gone now, but he tried this case and he was there representing Ms. Marshall at the trial. So that's the person who objected on behalf of Ms. Marshall.
And the trial court decided to move on with it?
The trial court said, well, the notice was sent, so I'm gonna move on with it. Basically, that's what I understood got said. But, I mean, the version of the statute that was in effect doesn't permit that to happen.
Did he ask for a continuance then?
I don't think so, Your Honor, but he continued to object to that issue to be heard. I don't think there's any way that anybody could say, and I don't think Mr. Wells has said that it was tried by consent under Rule 15, because there were repeated objections to it at the day of this hearing. So, unless there's anything else, I will sit down before I'm out of time, Your Honor.
Some things never surprise me. Gentlemen, we appreciate your argument. We will review the record and consider your briefs and oral argument and attempt to get you an opinion as quickly as possible. You may be excused. Thank you for being here today.